Morning, everybody. Welcome to the First District Court of Appeals. We have 4 cases to be argued this morning. I'm going to run through the list of cases, and if counsel could just identify yourself and indicate your readiness to proceed. First case is Morelia Group versus Wiedemann. Okay. Next matter is Edwards versus Horton. Okay, thank you. Next case is In Re JH. And the last case is State versus Glover. Okay, great, thank you. So for the first case, Morelia Group versus Wiedemann, please come forward. The light system, green means go, yellow means you have a minute left, and red means time to wrap up. And you, how much time would you like to reserve for? 4 minutes, sure. I'll keep track of your time. You may proceed when you're ready.
Will the light come on at 4 minutes?
I'll put the yellow light on when you have 1 minute left, reserving your 4.
Yeah. Oh, yes, sir. Thank you, Your Honor. Right. May it please the court, opposing counsel, my name is Jared Wagner, and I'm here today on behalf of the appellant in this matter, Sycamore Township trustee Thomas Wiedemann. This matter really originates and goes back to 2009-2011 time period when the CEO of plaintiff, Mr. Christopher Hildebrandt, alleges that he was attempting to sell land, facilitate the sale of land for his clients to the township, and that Mr. Wiedemann demanded bribes from him in order to assist the sale, make those sales go through. Again, that was many years, decades before the relevant actions in this case. But it's important because when, at the time that happened, Mr. Hildebrandt created a fake email account purporting to be from Mr. Wiedemann and sent emails to himself from that account to try to support his allegations of bribery, which we deny, but for the purpose of this motion being judgment of the pleadings, we agree that have to be deemed as admitted. And then circulated that to other people in the community unknown to Mr. Wiedemann. When Mr. Wiedemann found out, he filed a defamation action against Mr. Hildebrandt, which is pending in Warren County. The 12th District Court of Appeals just actually reversed the trial court's dismissal of that on statutory limitations grounds. And now that's going forward. In retaliation for that suit, Morelia Group filed this suit in Hamilton County against Mr. Wiedemann. And what they allege is tortious interference with the business relationship claim. And that all relates to an October 2019 public meeting. It was duly noticed. It was a public meeting. The records are before the court. The minutes are before the court in this case.
Well, yeah, but the minutes, I'm not sure that we're able to consider those because those weren't attached to the complaint. And I realize you've attached them to the answer, but I'm not sure that we're allowed to review those on a motion to dismiss.
Well, Your Honor, I have a couple answers to that. First, we cited the case law saying that official government records that are available via the internet, which these are, we provided that internet link in our briefs, are able to have judicial notice taken of them.
Is that Ohio cases or federal cases that you cite?
Both cases, Your Honor.
What's your Ohio case?
There is an Ohio Supreme Court case that's cited for that proposition. I can go to that portion of my brief. I will also note that they did not object to this below, and they've not even raised any objections to this, the consideration of those minutes here before this court. So there was never an issue that was raised, although I did.
Well, I mean, I guess part of my concern is, as I look at your brief, it seems to morph into summary judgment land, and because you're saying there's all these reasons why this deal wasn't going to go forward, and they're substantiated in these documents, but none of that's in the complaint. So I think, and this is a problem I see a lot of times with the city, where they kind of want their immunity issue decided at the pleading stage, which I get, but they're trying to inject facts that, are more appropriate for summary judgment.
We're just citing the facts that are available in the public record and that we believe can be taken judicial notice of, and also facts that they never objected to below or here before this court. And to Your Honor's point, there still aren't allegations. The allegations in this case, even putting aside those minutes, are that there is this animus that Mr. Wiedemann has to Mr. Hildebrand because of these allegations of bribery. And that therefore motivated his actions in opposing the sale. There's nothing alleged, even in the pleadings, to show that his opposing the sale was wrongful. And so you can't just have a malice towards a person as being, that alone is not enough to overcome immunity. It has to be malice that motivates wrongful conduct. Otherwise, anytime if a public official doesn't like a person and they have an interaction, he would be acting with malice or outside the course and scope of his employment.
Well, but I think it's more than just he doesn't like him. It's this history with allegations of bribery and, retaliation and everything else. So it's more than just like general dislike.
Granted, those are, if true, which they're not, we deny them, but we'll admit they have to be accepted as true here, are heinous allegations. But similar to like a claim against a police officer, even if they have a racial bias inside them subjectively, you look at objectively, did they have probable cause for that arrest? So objectively, did he do anything wrong here? Maybe he did in 2009 per the allegations. But that doesn't mean what he did in 2019 was wrongful. And that's the applicable question.
And that ultimately is going to be the issue later, but right now, you're saying we can look at these minutes. I question that. Like what Ohio case, because I can't remember what Ohio case you cited for that. I remember you citing federal cases. And, but when we look at just the pleadings in this case, we have to look at, did they set out a claim? And they didn't just say something conclusory in the pleadings. They actually laid out why they believe that there was malice.
Your Honor, I agree that they alleged there's malice, but they didn't allege that malice motivated wrongful conduct. So you can't just have malice itself isn't, because the definition themselves of malicious purpose within their brief, within the context of this immunity, is malicious purpose, willful or intentional design to injure or harm another through unlawful or unjustified conduct. So what they've done is they've alleged these facts that yes are bad, and they tried to say what he did here therefore was motivated, but what he did was oppose the sale, attempt to purchase land that the township didn't own for an amount $5 million below market value. And what he did was echoed by the law director who said, you can't do this.
Yeah, but I mean, that's like, there's no damages, there's no causation, and that means you win on summary judgment if you're right about all that. But my question is, if he has malicious intent to torpedo this deal, he could have had perfectly benign intent because those reasons you just articulated. But if he has malicious intent and they have substantiated that, is that enough to get past immunity?
And Your Honor, I don't believe so. I think he has to have malicious intent that motivates wrongful conduct. So he would have had to have either, there's no allegations that he attempted to solicit a bribe here in 2019. There's no allegations that he made any statements outside the township trustee meeting. There's no allegations that he did anything wrongful in that meeting, such as bring up personal problems he has with Mr. Hildebrand, make comments about Hildebrand, or try to meet with people and say, hey, we shouldn't do this. Now, to address real quickly Your Honor's earlier point, I did cite to a case from this court. When ruling on a motion for judgment on the pleadings, the court may take judicial notice of appropriate matters without converting the motion to a motion for summary judgment. This includes matters which are capable of accurate, ready determination by resort to sources whose accuracy cannot be reasonably questioned and are not subject to reasonable dispute. And that was a First District case of 2019, citing a Supreme Court case. And that's on page 5 of
Was that public records that they were taking judicial notice of?
Well, the next part down is the public records they're accessible via the internet, and that is a state X. Earl Everhart McIntosh Ohio State case. Okay. So to be honest with you, Your Honor, I got a lot of case law running through my head, but that the actual facts of the Buckeroff case versus Cincinnati, I don't know. I do know it stood for the proposition that we can consider public records, and you can consider them.
But, okay, were those cases on the Rule 12 stage, or were they on the summary judgment stage?
No, Your Honor, those are Rule 12. This actually says motion for judgment on the pleadings is the case that from y'all from the 2019 case. And the same I believe, although I don't want to purposely misstate, but I do think the sufficiency of the pleadings was at issue in the Ohio Supreme Court case as well. Because this is an issue we come up with, but when there's something, especially for race judicata issues, if you have a previous case, they say you can't have judicial amnesia, and I know that sometimes runs into you can't bring race judicata up and look at other side cases. So there is somewhat of a conflict on that. But I will again note, this was not raised by them, even in their brief now. But I appreciate the fact that the court, obviously, of its own volition can do it. It's a de novo review. So, I mean, the argument certainly isn't as strong without those public records, but I still think it's the same. And because again, to be outside the scope of employment, any of these things, it has to be an objectively bad act, not just that it's motivated. You can not like someone, you can hate them, you can have a racial or a sexist animus. I cited that case from Blanchester versus Curry, where the council people discussed a woman and they made rude.
But I mean, this gets back to the point you're making. Like, you're a councilman, you could vote for something, you could vote against something, and neither vote would be a dereliction of duty. But if you're voting against something because it is a product of some bias or some malice, isn't that still enough to get over immunity?
Well, I don't think it is, Your Honor, but even so, that's not what happened in this case, because it couldn't.
I know, but I'm trying to understand what your view is of the immunity statute.
My view of the immunity statute is you can't alone have malice. You have to have a wrongful act. So you still need to have some kind of motivated, you did something. I can't just have malice towards you and do my job if it's objectively still something that's appropriate.
But that's my point. So you could go either way. You have discretion to go either way as a councilman on whatever this issue is. But you go a particular way because you're motivated by malice, racial animus, whatever. Isn't that still wrong? Or are you saying it doesn't matter because they could still go either way?
Well, as long as there's a reasonable basis for it, and as long as he doesn't, so he'd still, one, be within the scope of his employment, because he's not stepping out and doing something outside of his job. And two, he's not, it has to motivate wrongful conduct. And that's the words in their own brief when they describe this.
But wouldn't, I mean, the statute itself says the acts or omissions were with malicious purpose, bad faith. So that seems pretty cut and dry.
Your Honor, I believe it still has to be wrongful acts, because you couldn't be liable then for doing something that's not wrongful even though you do it with a malice in your heart. It'd be holding you liable for almost any action then. And again, so, you would have, and I appreciate what you're saying about what's in the statute, but then when we look to the actual definitions that the Supreme Court's used for those terms, they're the ones that included those words, the unjustified conduct and whatnot. We also do have, Your Honors, the qualified privilege immunity for this.
And Ms. Ryder, you are at your time.
Okay.
So.
Well, thank you, Your Honor. I will reserve the rest of my time. Oh, there was.
That's okay. No worries. No worries. Thank you. Ms. Akers?
Good morning, Your Honors. I'd like to jump right in where we left off with this question about whether there has to be any kind of wrongful conduct. As you identified, Your Honor, there's nothing in the statute that requires that by any means. It refers to an act or omission outside of the scope of employment or that is done with malice or in bad faith. But even if we look beyond that, there is clearly a wrongful act here. We are connecting this earlier conduct, in fact, a series of conduct over many years where the defendant repeatedly demanded bribes and kickbacks from Mr. Hildebrandt and then threatened to retaliate against him if his demands weren't met. And what we see at the October 3rd, 2019 meeting is the enforcement part of that scheme. This is where he was taking action, taking retaliation for the fact that his bribes weren't met earlier. Clearly, that would qualify as wrongful conduct.
Ms. Akers, and I know this wasn't argued below or in your brief, but what is your position about whether we can consider those minutes?
Your Honor, we don't run and hide from the minutes. In fact, the minutes are entirely consistent with what we allege, which is that at that meeting, he stated a number of pretextual reasons for why the sale shouldn't go through. And obviously, at this point, all of those allegations in our complaint have to be accepted as true. So we have to accept the fact that those were merely pretextual statements. I'd also like to...
We accept the fact that they were pretextual because why?
Because what he was really motivated by was his malice, by his desire to retaliate for the fact that Mr. Hildebrandt refused to go along with his kickback scheme. And in addition, even if we do take judicial notice of the minutes, it's a bedrock rule that, in fact, is acknowledged in the appellant's brief, which is that judicial notice cannot be taken of facts that are in dispute. That would include the hearsay statements that are contained in the meeting minutes. So while this court could take judicial notice of the fact that these are the meeting minutes, that this is a record of what was said at that meeting, it cannot take judicial notice of any disputed fact in there. So for instance, the law director says during the meeting minutes that the property was not available for sale, or the entire development property was not available for sale at the time. However, in our complaint, we specifically allege that the township owned the entire property. At this stage of the litigation, obviously our allegations have to be accepted as true and all inferences have to be drawn in our favor. And like I said, we don't think the meeting minutes are at all consistent with what we have alleged here, which is that he went into that meeting determined to torpedo any deal, any offer that was provided by Mr. Hildebrandt. And during that meeting, he announced a number of pretextual reasons for his opposition.
And so, like, their point about there's so many reasons why this deal should not go forward, you would agree that if they were right on that, you would lose at summary judgment?
Well, I think all of these issues have to be explored in discovery. Because he could, so those are reasons that he could have reiterated because he thought the law director was saying them, but we should have the opportunity into discovery to explore and examine what he said to the law director before the meeting, what animated what he said during the meeting. Their entire brief is devoted to arguing the fact that he had these supposedly legitimate reasons for opposing the sale, but those are all factual questions. They cannot be resolved on a motion for judgment on the pleadings. And I'd like to just quickly go back to this question about whether there has to be any kind of wrongful conduct. Like I said, that's not contained anywhere in the code. And additionally, I would point your honors to the Senu Oki case, which we cited in our brief. In that case, the second district determined that the defendant employer was not entitled to qualified immunity, and did so even though the employee had specifically alleged in her complaint that the employer had hired a more qualified candidate for the position that she wanted. However, the employee plaintiff also said that the employer had gone out and specifically searched for someone more qualified, and did so because the employer was trying to retaliate against the plaintiff employee because she had filed a suit with the Ohio Civil Rights Commission. Again, here's this question of an animus, a desire to retaliate against the plaintiff, and that's what's motivating the behavior. But I don't think you would say
Then that goes back to my question to Mr. Wagner, which is, like, if a council person could go either way, it's a discretionary call. If they go a particular way, are you saying that that's improper if they were acting with bad intention?
Yes, and I think that's consistent with what the code says. If they take an act or omission with malice, with bad faith. And I would like to point out the fact we have alleged much more here than just he has a distaste for Mr. Hildebrandt. We have alleged that over a number of years, there was this consistent pattern where a bribe was demanded and threats were made that there would be retaliation if the bribe was not paid. And we say that the October 2019 meeting was just another instance where this retaliatory conduct was imposed on Mr. Hildebrandt.
But was there anything between 2011 and 2019?
Yes, and in fact, there was another instance where he retaliated against Mr. Hildebrandt. As we allege, he built this concrete barrier in front of one of Mr. Hildebrandt's developments, which prevented people from turning into, it was a Chick-fil-A.
He built a wall?
At any rate, but this was, this was an instance where he saw the opportunity to leverage his position as a township trustee to take retaliation on Mr. Hildebrandt for Mr. Hildebrandt's refusal to pay these bribes, and he did so again at the October 3rd, 2019 meeting. I'd also, with respect to the judicial notice, I would point the court to McKenzie v. Davies, which is a 2009 Ohio 1960 case. That was an instance where there was a question about whether or not service had been perfected. The plaintiff alleged that it had not. The defendant noted that there was in the record a return of service, and the appellate court said, well, it's fine for you to take notice of the fact that the return of service is in the record, but you cannot accept the truth of those statements, and you can't accredit the statements in the return against the statements made by the plaintiff, which I think is consistent with what we have here. And like I said, we don't run and hide from the minutes. Those are consistent with what we've alleged in our complaint.
Right. So what you're saying is judicial notice should be limited just to the fact that these are minutes from a meeting that occurred on such and such date, but then we can't assess the facts in those minutes.
Exactly, which are also consistent with the Rule 12 standard, which provides that all inferences must be drawn in our favor at this stage of the pleadings. I'd also like to remind the court that at this stage, none of the questions about the merits of the case are before us. It's really just a question about whether we have alleged facts sufficient to survive a motion for judgment on the pleadings on the narrow issue of immunity. So anything in the complaint, or excuse me, anything in the appellant's brief related to what his motivations were, whether he was right to do what he did, these are outside the scope of what we can examine today. I'd also like to remind the court as well that the Ohio Supreme Court has recently reaffirmed that only a notice pleading standard is required at this stage of the proceedings. We are not required to plead around the immunity issue, and we're also not required to plead the exception to immunity with particularity. But I would also say, I mean, our complaint makes very clear that there was this pattern of conduct over a number of years where the defendant repeatedly demanded bribes and kickbacks from our client and threatened to retaliate against our client if those demands were not met. And when he had the opportunity to take retaliation, he did, both in 2012 and then again at the October 3rd, 2019 meeting in question. I'm happy to answer any other questions the bench has.
Thank you.
Thank you.
Mr. Wagner, you have 4 minutes.
Thank you, Your Honor. To briefly address the issues of whether or not the hearsay is admissible, I haven't had a chance to brief that full week, obviously, because they never raised it below or on appeal. But I think, though, what the judicial notice says is you take judicial notice of this record, and whether or not there's truth of the matter, what was said isn't important. It's what was said itself. So it's not whether or not it's true that the law director said, or whether or not they actually owned it, or whether or not there was illegal provisions in the proposal. But it's true that the law director said those things during the meeting, not the substance.
But I mean, what if the law director was mistaken? Like, what do we do with that?
Well, but if he's mistaken, he's the law director, and so Mr. Wiedemann will be able to rely on that, and it shows a reasonable justification for his acts.
Isn't that like really getting into the merits, though?
Well, Your Honor, I don't think it does, because also, too, though, I think if you look at what Mr. Wiedemann said in that meeting, what's missing from that is anything that would show any kind of wrongful conduct.
But we have to construe the facts at this point in favor of the plaintiff. So wouldn't that be getting too far into the merits at this stage?
Well, I don't think you'd have to construe the facts of that, Your Honor, because the question is what he did was wrongful. And now, to real quickly go into the other grounds for immunity, the qualified privilege, they have to show a lack of reasonable justification to overcome.
If that is based, if you're basing that on the tort, correct? Is that what you're basing that? How would we have jurisdiction?
Because, and the 12th District has actually looked at this specific issue and considered on 274402C interlocutory appeal and said, because qualified privilege, and I cited this case in my brief, is an immunity, we're allowed to take, because that statute does not say just statutory immunity. It says we have jurisdiction here on interlocutory appeal over all immunity issues. And that's why I cited that in my brief to come ahead. Again, though, they've never objected to that, but we cited that in our brief. And there's multiple courts in Ohio that have held that qualified privilege is an immunity, not just a privilege. That's where I think that we have the jurisdiction. And I did address that in the brief. I can.
Well, but I think my concern about that is that turns any tortious interference claim into something that would be capable of immediate interlocutory appeal just because you lose as the defendant, whether that be at the pleading stage or at summary judgment.
If you bring a tortious interference claim against a public employee, Your Honor, I think that's probably right.
But I think what you're saying is that the justification is an element of tortious interference no matter who's being sued.
That's right, Your Honor, but we can't take an interlocutory appeal except for under 274402C, which says, so a normal person, if this was just against Mr. Wiedemann, businessman, and Mr. Hildebrand, businessman, he couldn't take advantage. We wouldn't be here at all, because regardless of any claims I had, I wouldn't be able to come up here. I wouldn't have the privilege of taking the interlocutory appeal. But that statute says, and the way the Supreme Court's interpreted it, because it's pretty clear, that it's not just statutory immunity, it's any and all immunities. And so because courts have said this privilege is an immunity, and the 12th District actually considered qualified privilege issue in the context of a claim against a political subdivision, that there's no case law contrary to that issue. And to take the point about the pleading standards, I found 3 cases from this court within the last couple months that affirmed or reversed and found immunity on the pleadings.
So what you're saying, let me just make this clear, is that if we find that statutory immunity does not apply, we could still find that qualified immunity applies and that we would have jurisdiction over your appeal. Correct? Am I understanding
Your
your
Honor.
argument correctly? All right. So looking at that Floyd case, the one that you cited, it wasn't necessarily addressing the privilege created through the tort. It was more on the common law privilege.
Well, that's the.
And it was more about, it was more relating, it was relating to the purposes of 2744.
Well, Your Honor, this is a common law privilege as well. We're not seeking a privilege under the statute.
But the Floyd case, at least the way I read it, was relating to the statute.
Yes, Your Honor, they still looked at the statute, but they also addressed the issue of qualified privilege on the interlocutory appeal. They didn't say, just as this court's done in some of these cases recently, that if there's a pendant issue that goes to the merits of the claim, we don't look at it. This is a weird tort because that privilege has been encapsulated as an element of the claim, but it's still a privilege itself. And so I still think, it's not a perfect case because the 12th didn't address this specific issue, but there is a case where on 2744 interlocutory appeal, an appellate court did address qualified privilege, and which is a common law immunity, and other common law immunities are allowed to be raised and addressed through 2744. We're not just limited to the statutory immunities.
Okay, so if we agree with you, are we bound by that case?
No, Your Honor, certainly not. I would never argue that. I put it in there because I was just looking to see what the case was. There were no cases, though, where they kicked it out, qualified privilege, and said, we can't consider this. And I cited all those other cases that said this is an immunity, not just a privilege. So it's the same kind of reason, just like you have for a qualified privilege in a federal case in 1983, we don't want it to sit there. We want the interlocutory appeal to come up to conserve the resources to try to look at this as quickly as possible. And that's the same underlying reasoning the Supreme Court has held for the statutory immunity, so even for this immunity as well. So,
Mr. Wagner, you are past your time.
All right.
We peppered you with questions.
I apologize, Your Honor. But in short, we would just ask for reversal and grant our assignment of error. Thank you.
Thank you both for your arguments today. The case will be submitted. We'll get out a timely written decision. Hope you all have a great day. Yeah, sure. Please.
I imagine you don't want it. Thank you.
Okay, the next case is Edwards versus Horton. Morning, Mr. Horton. You have 15 minutes to make whatever arguments you'd like to make. And the other side doesn't show today, so it's just you.
Yes, sir. The first argument I'd like to raise is the appellees never submitted a brief, and they never proved persona jurisdiction. And also, I never received due process. I never received any kind of documents from Hamilton County Child Support. Pursuant to their rules of civil procedures, according with Rule 471, 2008. It said rules. Sorry about that. I'm just a little nervous.
Okay.
Rules of civil procedure, service of genetic testing notice and order should be made by United States certified or express mail as evidenced by return receipt signed by any person or by personal services, which child support have not gave me notice, or I have not signed any kind of documents from child support services.
But you did receive the paternity order, didn't you?
No, I haven't received anything.
I thought you attached that to your
Well, I didn't
objection.
get it. I didn't get it personally. Someone gave that to me. I went down to Hamilton County and got it, but they did not mail, and they are not on the records stating that it was signed pursuant to their rules. Their rules is certain procedures they had to do to make sure that the defendant received documentation of an order. And child support is operating under administrative process, which is a quasi-judicial process because they're not a part of the judicial branch to submit any kind of documents or orders pursuant to the rule because they're not a part of judicial branch. And I have not, and that's violation of my due process because I don't, I never got any kind of documentation stating any kind of orders or anything. So everything was, the order was done under administration process, not judicial process branches. Then also, due process in juvenile proceeding must include adequate written notice and services under Article 1, Section 16, redress for injury. Due process, all courts should be open and every person for injury done him in his land, goods, person, or reputation should have remedy by due course of law and should have justice administered without denial or delay. I have not received anything for child support to even raise any kind of arguments or anything under administration process. It was just an order against me, and I didn't have remedy to make them arguments before they submitted an order in child support, genetics, testings, and all that so forth. And they also have not proven personal jurisdiction of the mother.
But do you live in Hamilton County?
I have a business in Hamilton County,
Okay.
and I never got service from Hamilton County for any process.
So your business has a PO box?
Yes,
Okay. I thought that's where the service was sent to.
and on the record, what's on the record for Hamilton County? What you mean service? What service?
So you never received service at your PO box, your business PO box?
No, I don't receive. I received mail there, but I never received anything from Hamilton County. And on the record, showing that it was a hand signature according to they rules on civil procedures. It's certain method or certain way they have to make sure the defendant receive service according to their rule. I mean, it says that service of genetic testing notice and order should be made by United States certified or express mail as evidenced by return receipt signed by any person or by personal services as an alternative to services made by the United States certified express mail. The service may be made by a commercial carrier utilizing any form of delivery require a signed receipt. Ain't nothing on the record showing reflecting that. I have not signed anything from Hamilton County Child Support or the other defendant, Tamara Edwards.
But ultimately, you did show up for a hearing, right?
I mean, after talk to the baby mother, she telling me what going on. So I didn't go to Hamilton County administration building. I went down to Hamilton County Child Support Court. This is what I'm getting from the mother that was going on, but I never got proper notice, service.
But if you went down to the court, did you let the court know, this is my address, here's how you contact me? Did you?
No, it was basically it was already an order issue. So I had to argue the order.
You
I never got-
you challenged the order
yes.
in front of the judge.
Yeah, so I never got service, but he wouldn't hear none of that, so that's why I'm here today,
Okay.
to raise them issues, because I wouldn't serve properly. I need to get due process. They violated my due process, the Constitution of the due process, where under Ohio Constitution, it said all men have a natural and indivisible right to worship Almighty God according to the dictates of their own conscience. No person should be compelled to attend, erect, or support any place of worship or maintain any form of worship against his consent. The provision interfere with the injured parts' inherent rights to raise his offspring without unnecessary government interference, infringement. Myers versus Nebraska. So I have a right to be private and work. Take care of my children. But like I was saying, I didn't get due process. I didn't get due process. I didn't get service. They never approved personal jurisdiction. So that's what I'm here
Mr.
today.
Horton, so you filed objections on August 31st, or August 23rd, 2021?
Yes.
And that's the first time that you filed anything with the court, is that correct?
Yes.
Okay, thank you.
So that's why I never have due process. When I went to court, it was already an order. So I had to object to that order. So that's how I end up here, because they went out again due process, going through administration process to make them arguments.
Okay, yeah, we understand. Thank you.
Yes, sir.
Anything further from you?
All right.
Thank you very much.
Thank
We
y'all.
appreciate
Sorry about that.
your-
I was a little nervous first time.
That's okay. No problem. We'll send out a decision to you in a timely manner. All right, have a great day. Next case is In re JH. Morning, Ms. Moss. How much time would you like for rebuttal?
3 minutes.
3 minutes. Very well.
May it please the court. Jessica Moss on behalf of the appellant JH. This case stems from the juvenile court improperly issuing a warrant against JH in the height of the COVID pandemic in 2020. The assignments of error here concern whether the juvenile court abused its discretion in admitting evidence and whether the adjudications were against the sufficiency and manifest weight of the evidence. I'm going to first focus on the issues regarding judicial notice and then address the weapons under disability and carrying concealed weapon charges. As to the first assignment of error, the judicial notice of the entry dated 8/4/2020 in a separate delinquency case was not harmless. It was not cumulative of other evidence, and it was prejudicial to JH. Now, a court can only take judicial notice of proceedings in the immediate case, and that was not done here. This court took judicial notice of an entry in a separate case against JH.
And so the state agrees with you on that point, and obviously makes a harmless error argument, and I think focuses predominantly on the officer's testimony that he says, I think like something like, I think he's got a warrant for aggravated, whatever it was. So the question I have is that testimony sufficient under the statute to substantiate that he was under a disability or not?
We would assert that it is not. Believing that somebody has a warrant is not enough. It doesn't say what specifically the warrant was for, when the warrant was issued, what jurisdiction the warrant was issued from.
Do they need all that detail? Or they just need to know just that there's a warrant out there? I mean, they were going into this house, I guess, specifically, were they looking for him? Or, I mean, why were they going into this house?
They went into the house to look for JH, but the fact is because JH was charged with having weapons under a disability under the provision that he was a fugitive from justice, that's what makes it necessary.
But why do you need all the detail about the warrant? Rather than just the officer saying, I think he has a warrant?
So, and I went to in my second assignment of error, there's a split between the districts. Beyond just the knowledge of whether or not somebody has a warrant, the consensus between the districts is whether or not someone has incurred guilt and is sought by police in connection with some offense. So we look at, okay, whether or not they're sought by police here, whether this was valid. And in this case, it was not. And whether or not somebody's taken some affirmative action to avoid capture, with some districts requiring leaving the jurisdiction and others only requiring fleeing from police. So because there is this consensus that something more needs to happen, specifically leaving the jurisdiction, knowing what jurisdiction that the warrant was issued from is important to know if that's where they are at the time the police show up.
So the argument you make in your brief is that the warrant was impermissible because the hearing from which it stemmed was not something where he was supposed to show up to begin with. And so, but my question is, did you all develop that argument below to substantiate that he didn't have to be at the hearing and the warrant was erroneously or improperly issued?
So trial counsel on these particular cases did raise that issue at trial as well as on objection. Now, certainly the best case scenario would have been objecting to the entry that put on the warrant, but from the entry, it doesn't even appear that there was counsel at the hearing. So while that didn't happen, that still is an essential element of this offense of having weapons under disability, so that still has to be addressed here.
Ms. Moss, what effect does it have that your client admitted that he knew he had a warrant for aggravated robbery? The audio was kind of fuzzy, but it sounded to me like the officer asked, "What's your warrant for?" and your client replied, "Aggravated robbery," and then they went back and forth for a couple seconds discussing that.
And I agree so there was earlier questions asked of JH about whether you had a warrant. He said no, and that was repeated several times. That audio clip at the 27-minute mark, or a little bit after, it was hard to hear, and I listened to that over and over to figure out exactly what was being said. He does say something about aggravated robbery, but there are some pieces that are cut out, so I'm not exactly sure what he said. But that was also after officers told him on multiple occasions that he had a warrant. And so I think if he is responding at that point in time, 27 minutes into the police coming into this home, he may have realized, I had this other charge, maybe there's a warrant out because police are telling me I have a warrant. At the beginning, before police told him he had a warrant, when they asked him, he said, "No, I don't have one."
Was he Mirandized at any point?
He was not. Well, he was not in the video that I could see. There were points where the video cut out completely for segments of time, but from my understanding, he was not Mirandized.
So for this case, is the only way for the state to have, in your opinion, or your view, have presented sufficient evidence is if they had presented the actual warrant? Is that what your argument is?
So on
the actual warrant,
the weapons under disability, I think they certainly could have had a certified copy of the entry. That would have been the best case, evidence for them. And that's what this court looked at in Ray JT of having some other evidence. Hearsay was not enough. Pulling up the records in a database showing warrant was not enough. And not only having this warrant, but also there has to be some other step taken to elude police or to leave the jurisdiction to be a fugitive from justice. It's not just simply having the warrant, but this further step. And that's the consensus between this district, the 2nd district, the 5th district, and the 8th district. Something more has to happen.
So in this particular case, under these facts, it's not just the lack of, the warrant itself, but there's the extra piece that you're saying is also missing.
Correct.
Okay.
And
So, I'm sorry. Continue with your answer. I thought you were finished.
so even if you take out this part of whether he knows or not, since there is a split between the districts, there has to be this other piece to show he did something, and he was arrested without incident. He was sleeping in this home, and he didn't flee police. He didn't do anything.
Just so I'm understanding, if we determine that he knew he had a warrant, regardless of, when he admitted it, if we determine that he knew he had a warrant, is the fact that he didn't leave the jurisdiction and didn't, I guess, actively try to elude, was there any other evidence that he tried to escape or elude police?
No, there was no other evidence of that, and the officer specifically testified that he was arrested without incident.
Correct. So there was no other evidence that he, changed houses every night or anything else in the record to suggest that he took active steps to elude police?
Correct. All we know is that police went to this house believing that he was there. That's where he was sleeping. Nothing else was put in the record about how long he was staying there. Presumably that's the house that he was living in. We don't know. And as to the carrying concealed weapon, not only would the weapon have to be concealed, but he would have had to knowingly and voluntarily conceal it. And here, the weapon was not concealed. It was discernible by ordinary observation for the officers to immediately see it. They didn't have to perform a search, careful, thorough, or detailed to see it. Police immediately, in going into that room where these boys were sleeping, immediately said, guns and knives in this room. And prior to physically retrieving the gun from JH's pocket, the officers said, JH has a gun. And he actually started to say, I have a gun. And they said, I know. So they were able to see this immediately. JH did not try to hide the gun. This is the same as, when officers are coming into a bedroom with the lights off, turning the lights on, immediately being able to see that. And that's what happened here. They were immediately able to see this.
So I thought the gun was in his pocket or something.
So in the body worn cam, it was blurred out, so we can't see ourselves what it looked like, other than the officer's statement, guns and knives in the room immediately when they walked in, and saying, there's a gun in his pocket. So I don't know how.
Did the officer not testify about where the gun was located?
He said it was in his pocket.
Okay.
But you can hear in the moment that the officer, before pulling it out, said, I know that there's a gun in here.
But isn't putting a gun in your pocket a method of concealing it?
If it's concealed, and in this case it wasn't, if the officers had to then perform a search and then pull it out and not know what was in his pocket, that would certainly be the case. But here they knew it was a gun at that time.
So you can't get charged for carrying a concealed weapon if you walk around with a gun in your pocket and the handle sticking out?
There are cases where individuals have been convicted of that, but there has to be this apparent being a gun. It can't be a guess that there's a gun, and there was not a guess in this case. Additionally, we have a situation where with this knowing and voluntary, and he was sleeping. We don't know how this gun got into his pocket, and possession has to be more than a momentary and voluntary possession. We'd also.
So was there any, there, correct me if I'm wrong, there was no testimony about how the gun got into his pocket, correct?
Correct.
Thank you.
Yes, he was sleeping. Police got him out of the room, took him out, and immediately handcuffed him. There was also not chain of custody for this gun. And in the first assignment of error, we talked about authentication. And here the officer said he knew this was the gun because it was, he remembered the light blue color, but there was no testimony saying that this was a unique color. And I will reserve the remainder of my time.
Okay.
Thank you.
Thank you. Mr. Heflin? Morning.
Good morning, Your Honor. May it please the court, Alex Heflin on behalf of the state. I'll start, I guess, with the first assignment of error, just discussing the warrant, but it really kind of touches everything in this case. The state does submit that that was harmless error, as I stated in my brief. I'm not sure I'm really following the argument on that. So it seems to be that the warrant was prejudicial enough to not be harmless, but also not bad enough to at any point challenge with a motion to suppress or something other than judicial notice of an entry. I'm not sure I understand that. I think the record.
But if the court was going to take judicial notice of it, presumably it would have denied a suppression motion on it, don't you think?
I'm not sure. I mean, if the issue, it wasn't litigated below, essentially. If the issue, as I understand it, is, well, it shouldn't have been issued at all, I think that needs to be discussed before here, certainly.
Yeah, and that was part of my question.
Right, yeah, so I don't know that we know. I'm not sure. I also don't think part of this, it's an aggravated robbery, and whether it was there was some questioning before about whether the officers told him he had a warrant or whatever. They did not tell him that it was for an aggravated robbery. He at some point was aware that he was facing an aggravated robbery charge, and then went without contacts on that aggravated robbery charge for almost a year. I think it was your point, Judge Bach, Mens rea, this court, the only thing on fugitive from justice that this court really has said is that we don't have to prove a mens rea. I think it helps if you show it, and I think knowing that it's been a year since you've had a contact, I don't think that.
But isn't this in the middle of COVID? I mean, like crazy stuff is happening in terms of court proceedings, right?
Sure, they are, and there's a warrant issued in this case too. If we want to, I mean, the record is what the record is,
Yeah.
and the warrant is unchallenged at this
I'm
point.
just saying,
in
like,
any-
if your response is like, well, you should have done something in that year, and I guess my comeback to that is, well, things are in a little bit of disarray with COVID, and so the fact that you haven't had a court date isn't necessarily probative that you're, absconding or fleeing.
I don't know that I don't think it's probative that the case disappeared either. I don't know that it can be argued.
No.
It's at best a neutral.
Right.
And I think, excluding that year, then certainly when this comes up, bring it up, address it. If you're
What
like,
about,
no,
what about Judge Krause's question that, like, do you have to have like a certified copy? I mean, that's how we normally see it.
So, sure, I don't know that you do, and I think that's again part of the problem with this being litigated for the first time, essentially right now. The definition of fugitive from justice, I think, with the appellant's argument, I don't know that a certified copy would work. So I don't know. They're citing the case law from extradition cases and things like that. So even if we had a certified copy of the warrant and put it in, I'm not sure that they're saying.
Well, I think what they're
that's good.
saying is like you have to have that plus the effort to, not comply with warrants.
Sure,
You would have
right.
to say that like, hey, we notified him and he disregarded or he fled the jurisdiction or, something
Right.
like that.
I'm unaware of any case that says you have to have a certified copy of the warrant. I think there is.
So what's good enough? You're saying that the officers, this was kind of vague testimony here. That's good enough?
I think so, in conjunction with the fact that they testified they're fugitive apprehension officers. This wasn't, and I'm forgetting the initials of the case, where the juvenile was stopped for whatever, being suspicious or something, run them in the computer and say, oh, there's a warrant. This is the only reason they're at this house is for this defendant. And the only reason they go to houses is to serve, to arrest people with violent warrants.
So they came,
So-
so just so I understand the record, they came to this house specifically for this defendant, not, because there were other people there.
Correct.
They weren't there for the other people.
No, they had an arrest warrant for this defendant. That's why they're there. And they do, he does say, I think an aggravated robbery and some misdemeanor warrants. He says, I think. I think the procedural posture of this case also sort of illustrates there was a warrant. So I don't think there's never been any litigation about whether there was a warrant that was valid. And again, this hasn't been raised, if we were to go down that road, I would proffer that since this all happened, the officers that executed that warrant, I'm sure they were holding a facially valid warrant. And so they're operating under good faith that this is a good warrant.
Right. Whether it should have been issued because of COVID or whatever,
Sure, the morning of.
The issue is there was a warrant. They were
Correct.
there because there was a warrant.
That looked good, and when they knocked on that door, there's no malicious intent or anything. They're holding a warrant for this defendant. So, getting to,
But couldn't he, and maybe I'm misunderstanding you, but couldn't he still defeat the weapons under disability charge by showing that the warrant was invalid to begin with?
Sure. Yeah, I think he could. Yes,
Okay.
yes,
All right.
yeah. So this is kind of a confusing, we're sucking in a motion to suppress on a warrant into an element of another offense, and it's confusing everything. I think when we look at the case law, I guess my comment on the lack of a definition of fugitive from justice, I don't think the extradition cases are incredibly instructive, because extradition, as everyone is aware, is grabbing a person from a jurisdiction and removing them to another. I think if you're going to look at that, you probably want some evidence that they ran away from jurisdiction A and are in jurisdiction any other. I don't know that if it's just a warrant case, that's necessary.
So let me see if I'm understanding your argument correctly. So what you're saying is that if a person knows that there is a warrant out for him or her, that if they don't turn themselves in, that's enough?
I think, Judge, in certain cases, yes. I think it's been almost a year in this case, and Judge Bergeron, I understand COVID, right. Tricky to every, especially precedent from not COVID. I think if it were a week, maybe that's not close enough. Once you start getting into a year, I think that's good circumstantial evidence that this case was charged and it's still out there. I would also point, again, it's not required to show mens rea under this court's precedent. I think it could help. But I don't have a specific timeline for when that would transfer, a week, maybe not. I'm not sure how those get served. I'm not intricately aware of that.
So there's no affirmative action that a person would have to take to be a fugitive from justice if they knew they had a warrant?
I don't know that there's a rule that I can think of. I think in the 1 week case, yeah, maybe you need them to jump out of a window or something when you show up. That would help. I'd feel better about that case if I had that, if it were only a week. With a year, I'm not really that concerned about an affirmative action. I think also the record of this case, he was asleep. They woke him up. I mean, it worked out. They woke him up, and then he was immediately taken into custody.
Do we know anything from the record about what this house is, like whose house it was, or why he was there? Or anything?
There was it's in the body-worn camera. There was an objection made to hearsay contained in that was sustained in a kind of blanket form. So I don't believe that it was.
So we have no idea why he's in this house sleeping?
No.
Or what led
No.
the police to believe that he was going to be at the house?
No, there's nothing there. The homeowner makes some statements that that were objected to.
Okay.
And not to be considered. There's no evidence, we talked about it briefly, this is in terms of the affirmative defense of Castle Doctrine or something like that. There's no evidence that was put forward that it was his house.
That's his burden.
Right. So
Right.
we didn't necessarily, I don't know that that's required either to carry the burden for the weapons under.
Well, I was just like in the context of him being a fugitive, like was he
Correct.
hiding out?
Correct.
Or, they had been looking for him somewhere else and they got a tip that.
Yeah. They only
we have
said.
none of that information.
We thought he was in this house.
Okay.
I don't believe it's not the same address that's listed in court documents. This is an older, that's as good as the evidence gets. Sorry, 1 second. In terms of the concealment issue, I think Judge Krause, I believe it was you, that pointed out, this court has plenty of cases saying a gun doesn't have to be 100% concealed. I believe the testimony was I would dispute, I guess, the fact that he was just like, oh, gun. I think he says it was in his pocket and it was heavy. So that to me connotes having to feel whether or not it's heavy. I don't think it was that instantaneous. Even if it is, I've had cases too where you pointed out, if there's a magazine sticking out of a belt, that's a firearm. It's partially concealed. I think that still, under the case law, meets the definition of concealed.
If a handle's hanging out, it still meets the definition.
Yes, yeah. So I don't think there's much of an issue there. I believe I mentioned the affirmative defense. If there are no other specific questions, I'd just ask that you affirm.
Great, thank you. Ms. Moss, you have 4 minutes.
Thank you, Your Honor. Excuse me. As to the suppression issue, while a suppression motion could have been filed, I don't know that would have changed what would have had to be proven at trial in regard to the weapons under disability issue. I think police, were acting on what information that they had, but whether or not this was a valid warrant, whether or not a person has incurred guilt and is being sought by police in connection with that, that again goes directly to the elements of this having weapons under disability charge. Additionally, the fact that it was this fugitive from justice unit or fugitive unit, the information they would receive, I would liken to the In Re JT case where the officer was pulling up the information of that juvenile and determining that that person had a warrant. And that, all the information we have is something likened to that. We don't have anything more. We don't have what other information they have other than hearsay of getting information about where JH was or whether the fact that he had a warrant. Again, I would go back to this, some affirmative action has to be taken, and that's what all of the districts, including this district, has looked at. It's not just the warrant, but it has to be something more.
In what context were those cases in this district, from this district? Was it a apprehension case or an extradition case, or what was the context?
The context of that case was, I think they were investigating something going on. I don't remember if it was a shooting, and they came across a juvenile, pulled him up, information, found out that he had a warrant, and that's and then arrested him. And I believe that there was a firearm on him, and that's where that came up. And so this court looked at this fugitive from justice having weapons under disability and wanting more than just hearsay, wanting a certified record, wanting specific information of what the actual charge was.
So we would need more information in this case when you say something more, that maybe he was hiding out in this house, or hiding out would be more, right? Like that he's avoiding being found because he's hiding in somebody's home where he's not normally living, right?
And I think give the split between the districts. Some districts are saying, yes, hiding out from police, doing that, certainly what other districts are looking at. You have to actually leave the jurisdiction from where a warrant was issued to be able to fall within that being a fugitive from justice.
But the record's pretty void in regard to whether he was hiding. I mean, that was the question I asked the state, was why was he in this home, and we don't have any information for why.
Correct. All we know is he was sleeping in this home.
Okay.
We don't know for how long or for what purpose, but this is where he was sleeping. For these reasons, we would ask that this court reverse the juvenile court's adjudications against JH.
Thank you. Case will be submitted. We'll get out a timely written decision, and hope you both have a great day. All right, last case is State versus Glover. Ms. Compton? How much time would you like for a rebuttal?
10 or 5 on. May it please the court, Your Honor. Your Honors, Beth Conkin on behalf of the defendant appellant Tommy Glover. I'm going to focus my presentation today on our against the manifest weight of the evidence argument. I realize that we have a bench trial here, and the state has argued that there's a presumption that in a bench trial, the trial court considered only relevant material and competent evidence, unless it affirmatively appears that it didn't. And in this case, the evidence against Mr. Glover was inconsistent, it was weak, and it was conflicting. There was no competent, credible evidence against him other than the fact that it was a heavy-set African-American man that the victims each described as being their perpetrator.
I thought certainly the victims unequivocally identified him.
In
and
court.
They could be wrong.
In court.
Right.
And that's part of the problem with the case, is that these people were clearly victims. This is not a situation where, you're claiming it was rape and the defense is saying it was consent. These people were clearly victims. Part of the difficulty you have in cross-examining victims is that they don't think they're lying. I don't think that these people thought that they were lying or that they were making it up. The problem is, if you look at the information that they gave to the police immediately following these incidents, the only information that they could provide consistently across the board was that it was a heavy-set black man.
Well, some of them provided that he had hand tattoos.
One person said he had a hand tattoo, and that was Mr. Moratine, and he said it was a spider web hand tattoo. Then you have Mrs. McNamara, who adamantly testified there were no hand tattoos. I saw his hands, he didn't have gloves on, there were no tattoos on his hands. Then you have Mr. Schur, who was victimized twice. We don't know whether it was by the same person or not, because his first incident was with two people, a skinny black man and a large, heavy-set black man. The second time, it was only a heavy-set black man. The first time, the large, heavy-set black man was wearing a hoodie and a jacket. He could not remember the color. He identified the assailant as having a big, bushy beard and long hair.
Didn't he testify that the voice was the same in both situations?
Well, he said that. Whether that's enough to identify the person as being the same in both incidents, I question. He said that the second incident, the man wore a mask. I know that, masks distort your voice somewhat, and there was limited conversation between the two. So for him to go from saying a misdescription or a changed description of the assailant at the time of the incident versus what he said in court, that the man had a scrubby beard and short hair, I think is significant in the sense that it's inconsistent. Mrs. McNamara was unable to give any description of the person who robbed her, other than to say he was a heavy-set black man wearing a maroon T-shirt, white shorts, and tennis shoes, and had jerry curls. She could not give any identifying features beyond that. And yet, it was the testimony of the police that said she called the police after seeing and said that she had seen her assailant on TV, identified as someone who was wanted in connection as a suspect in several armed robberies. It was only that viewing of Mr. Glover's face on TV that prompted her to identify him in a photo array.
Didn't she refute that, though, at trial?
She did, but the police officer said she called.
Okay,
And that
so the police officer testified
Yes.
that she said this, and then she said, no, somebody else told me about him being on the news.
Correct.
Okay.
Then you have Mr. Schur, when he did identify, he was shown a photo array after this, Mr. Glover had been arrested. He said, I'm 90% sure that it's Mr. Glover, that it's this one, number 5. But I'm 50% sure it's another person, and I'm 30% sure it's someone else. Mrs. McNamara was the only person who said she was 100% sure it was Mr. Glover, but she said it only after having seen his face on TV. Mr. Moratine couldn't identify anyone from the photo array, and Ms. Bolander said it was someone else. It was number 2. And yet, despite all of that, they all identified Mr. Glover in court with 100% certainty that he was the one who had robbed them.
Well, he was sitting at the council table in a prison suit, right?
Absolutely. The only heavyset black man in the courtroom, the only black man sitting at the council table in a prison suit. So in-court identifications have the susceptibility to be I guess, unreliable.
Is there any case law saying that we should basically discount in-court identifications if it doesn't match what the victim identified previously? Like, for example, in the case of Mr. I'm not sure how to pronounce
Sure.
this. No, Mr. Matanguian?
He didn't identify anybody.
Correct, but didn't he make an in-court? Oh, he was unable to provide
He
an
was
in-court.
the only
That's
person who
okay.
admitted that he didn't know who
So
it was.
if we're in a situation where a person doesn't identify somebody in a lineup, or doesn't identify them at all pre-court, and then in court is able to identify the person because they're sitting at the table. Is there any case law saying that we should discount that sort of identification?
Well, there's the case law that says when you're determining how to weigh the in-court identification, how much weight to give it, you need to look at opportunity, how long they had to view him, the description they gave at the time, and I do cite this case in my brief, and then, or whether there's an inability to identify the person. And so we have all three of those
But
situations.
those would all be just under the broader manifest weight rubric, right?
Yes, but specifically as to in-court identification. The testimony on the trial ID was just unreliable, and you can't use, even if you want to say that Mrs. McNamara, suddenly had an epiphany and realized that this is who it was and was able to identify Mr. Glover in a photo array and then later in court, you can't use her testimony, the evidence in her case, to bolster the evidence in other cases that don't otherwise rise to the level of beyond a reasonable doubt.
So he also had a jacket that was the same jacket as at least one of the instances at the ATM where the heavyset black man was wearing a jacket that
Once.
looks like
Yes.
it was one time.
Which victim was that?
That was Mr. Shore
Okay.
in the first incident. The second incident with Mr. Shore, the heavyset black man was wearing a green T-shirt. Then the incident with Mrs. McNamara, the perpetrator was wearing a maroon T-shirt. And then the incident with Bolander and Moortime, it was a dark hoodie, but no testimony with regard to, a reflective,
But Mr. Shore
emblem.
was robbed once by somebody that had the same jacket as your client. Is that
Well,
correct?
I don't know that a black jacket with a reflective emblem on the sleeve is definitive enough to establish that that's a causal link between he obviously did it because he had a black jacket on.
No, I'm just saying that that's a piece of the piece of the evidence was that one of the victims was robbed by somebody who had a jacket that was similar to a jacket that your client owns.
Yes,
That's
and
a
then none
piece.
of the others was.
Okay.
And then the same thing with the crossbody bag. The state makes a big deal at the trial, and the court relied on it significantly. The fact that during the robbery of Bolander and Moortime, that the heavyset man had a Nike crossbody bag on. The Nike crossbody bags are not unique. They're ubiquitous. And to think that a black jacket with a reflective emblem on it in one of the robberies, one of the 5 robberies, and a crossbody bag in one of the 5 robberies is sufficient enough to be to establish a pattern or a practice that, they're not distinctive enough. And if you look at the photos from the trial, the photo of the crossbody bag in the ATM my memory is that it was all scratched up and beaten up, and some of the lettering was peeling off, but the one that they saw that Mr. Glover was actually wearing was like pristine. And all of these incidents happened within like a month, from the end of May until the end of June of 2020.
Ms. Conklin, how much time does she have? I want to turn your attention to something else. Do we have any discretion after Jones on the sentencing?
Yes.
Because by my calculations, the sentence was within the statutory range.
The sentence was in the statutory range, but it's not supported by the facts.
Are we allowed to look at that?
Yes.
After Jones?
It says, yes, the statute says unless it's not contrary to law, which would be outside the statutory range, or not supported by the evidence that was adduced. There was a sentence of this magnitude is reserved for the worst of the worst. even if it is within the range. This man had no history, no convictions. He's 22.
That goes to the individual sentences, right? So the judge first has to determine between 3 and 11 years, I guess, is what she was
Right.
looking at.
And
She
then-
picked 7.
And then ran them consecutive.
And random consecutive, and the question is on, what do we look at on when we're determining consecutive? I mean, she says the magic words.
Right? Yep,
Are you saying the record doesn't support those magic words?
I am.
And
He
how?
didn't hurt anybody. There was no physical, I realized that this would be a hugely traumatic event. I'm not disputing that. I'm not trying to downplay the impact that this had on the victims. But he never physically hurt any of the victims. Didn't hit them, didn't grab them, didn't even touch them.
It was psychological.
No, I agree. I agree. It's emotional, having someone point a gun at you and threaten to kill you or hurt you if you don't do what he says. Certainly bad, but we have murderers who don't get as much time as he got. We have repeat offenders who don't get as much time as he got. And the fact that he's not eligible for parole until, I think, 2060 is ridiculous.
Well, he got more than
You got 60 years.
twice what the state asked for.
Yes. Yeah, the state had initially offered a deal of 15. He turned it down. At trial, they suggested 25, and the court gave him 60.
And that just had to do with the 5 victims. She chose 7 years for each person, random consecutive.
Yes.
Plus the gun
The
specs.
gun specs. And, the trial court was caught up in the incidents that occurred. And I think that clouded the trial court's judgment in determining, one, that these in-court identifications were somehow meritorious and competent and reliable, when everything to the contrary, or everything else suggested the contrary. And these people were not reliable witnesses. They tried their best, but we know from the information that they gave to the police immediately following, and the fact that they were unable to identify with the requisite degree of certainty necessary to convict someone, reasonable doubt, that the court lost its way. And I realize that that's unusual, but
And you're past your time.
I'm sorry.
That's okay. We ask you questions, it's fine. Ms. Adams, good morning.
Good morning, Your Honor. May it please the court, Ms. Conkin. I think that the essence here of the argument is that the trial court relied on weak and inconsistent statements or identifications. I think the court clearly got that this was identity was the issue here. And I think since we have so many victims in this case, it's important for that trial court's assessment. Each individual's different. They perceive things differently. And all of that was born, all of these issues that are being raised on appeal were
was there
borne
any
out
effort-
through cross-examination.
Was there any effort to bifurcate these cases? Did anyone object to trying them all together?
I'm not
No, I
certain
was just curious.
in the record, no. I don't know that was attempted. But regardless, I think if we look at the circumstances of these aggravated robberies, the MO, if you will, is the same. Get the person away, take them to an ATM, and even to in fact, unfortunately, the poor individual who was victimized twice, we even have the individual knew the increments, the limits that this individual had on his ATM and made him withdraw those same increments.
Well,
at
clearly
one
it
point.
was, I mean, it seems like it was the same person for all of these robberies, and it was always a heavy-set black man
Correct.
for all of these robberies. And I think the question is, did the court lose its way in determining that it was Mr. Glover based upon just how wildly inconsistent everybody's testimony was?
And I don't think that is probable in this case. When you look at, and this is over, a 3-month period of time before he's arrested. So the end of May, the offenses begin, and then we have circumstances where he is apprehended by the police with, the cross, and it's not just the actual bag, the manner in which it's worn was similar as to what was described as well. So I think all of the circumstances here, and we have, again, voice is important here, especially with Mr. Shores, if I'm saying his name correctly, the individual who was robbed twice, he indicated it was absolutely, he felt confident the same person. So, and each of those individuals had the opportunity to hear his voice, and regardless whether he was wearing a mask, they saw his eyes, his mannerisms.
Were there jail calls admitted into evidence?
Yes.
The judge I haven't listened to those. What was said on the jail calls?
Well, there was, I think a lot of that had to do with trying to identify the co-defendant. There was some, and so that's the essence of the majority.
It wasn't, the jail calls weren't admitted for an admission by Mr. Glover? Like, there was no indication that he admitted to?
No, I think that circumstantially, obviously, he knew a bit. I think that's, and the jail calls get overwhelming, listening to them and trying to distinguish one from the next. So from my memory of those, there is some circumstantial, what he knew. And I think in this case, I think he was trying to protect that co-defendant. I think that's glaringly obvious, and that was maybe why that was presented in the trial. But regardless, I think that when we look at the opportunity for the trial court to consider the cross-examination, all of those issues that they're presenting in appeal were bore out through the cross-examination. All the questionable or inconsistent aspects or what they characterize as inconsistent aspects of the identification were presented to the trial court, and the trial court was in the best position to weigh that, and she found that it wasn't a problem in this case, so the state would ask that.
Well, Ms. Adams, I have a question for you about one particular victim here. So Mr. Mantaguin, I believe is how you pronounce his name, he was not able to provide any identification of Mr. Glover at all, either before court or in court. Now, I know that there is testimony from, I believe it was, I can't remember which of the two victims that happened a little bit later, about them joking about robbing somebody earlier. Is that the only thing tying Mr. Glover to Mr. Mantaguin?
It was his car that was stolen. They took Mr. Mr. Glover took his car and took that to the next set of victims, the Xavier. This is all within one street over, less than a block from Mr. Manguin's residence. They took his car over the next street and then took the two Xavier students.
Okay, thank you.
Can I ask you just a question about the sentences? Because, obviously the judge, almost tripled what you all were asking for. And I just found it concerning that the judge says there's no trial tax here and then drops the hammer down. That's like 4 times the plea offer. And I'm not saying that it has to be like right by the plea offer or anything, but it's troubling to me.
Well, I think it's the risk a defendant runs too. That's because, number one, I don't think anyone realized and I don't know if he was disabled, or there was certainly the first victim, the victim who was victimized twice, had suffered from some disability, for lack of a better word. And then you have the trauma of the second victim, the nurse's aide that was just getting in her car. All of that, I think, played out in the trial that, perhaps if this had been a plea, you wouldn't known the gravity, and Ms. Conkin indicated they weren't harmed. I think this trial bore out just how harmed they all were, even the two Xavier students. The poor girl who, she's a nursing student, and all of the information that she put out, all the counseling that she has to, go through, she moved across the country. All of this information the court had before her. And I think it's the sheer magnitude. In a murder case, yes, they take a life, but it's usually one victim. Here we have 5 separate victims
Yeah, and
that suffered at varying
Right.
degrees. And so I think this was absolutely within the
I mean,
court's
I'm
reasoning.
kind of struck because we have a case before us right now where the individual was in a bar incident, bar fight, and pulls out a gun, racks a slide, and points it at 3 people. Fortunately, didn't shoot anybody, but he gets 180 days for that. And granted, this case is more serious, but still, like pointing a gun, threatening to shoot someone, and the disparity in those sentences between 180 days and 60 years
Well,
is.
you got to look at all the circumstances here. These were individuals, they were forced at gunpoint, and oftentimes their own, well, actually in all the cases, their own vehicles, forced to a bank over a period of time. And, the trauma of that, knowing at any minute this person could just pull the trigger and end my life. So I think when we look at that, and then the brazenness of this individual, and nothing speaks more clearly than, this is a dangerous individual. He's going to do it again. He's done it time and time again. The same victim twice. I think that speaks volumes, and I think that was borne out through the trial, and the trial court had the...
Going along with that, though, what was the difference between when the state asked for 25 years versus when the trial court imposed 60?
I don't know. Obviously, that's not in the record.
There was no testimony between those two, correct? When the state asked for 20 to 25, I believe it was, that was at the end of trial?
With sentencing.
I believe so.
Yeah,
that was
sentencing.
the...
So there was no, it's hard for me to understand where that jump came from.
Well, and when the state is making that recommendation, the state has, obviously spoken to the victims, but the victim impact statement, the defendants, the PSI,
Sure.
all of that, the state isn't privy to.
That's what
at
the
moment.
victims wanted 25, right?
I believe that, and that could just be one victim set forth that, but that all, the trial court has the full picture when they're crafting a sentence. So the fact that the state made a certain recommendation or, even a certain offer prior to, really, that means nothing to the trial court. The trial court's tasked with looking at the entire volume of information in a case, and that's exactly what she did here. And I don't think there's any error or any reason for it to be changed.
Thank you, Ms. Evans.
Thank you.
Ms. Conkin, you have 4 minutes left.
Again, I would just reiterate the fact that even if you believe that the same man committed all of these crimes, which I don't think is necessarily a given, but if you believe that, there is still the problem with identifying Mr. Glover as that perpetrator beyond a reasonable doubt. There's simply no evidence, identifying evidence that these victims gave the police that would link Mr. Glover to these offenses. They didn't identify, they didn't describe him accurately or with any specificity. He's a heavy-set black man, in one case with a black jacket with a reflective emblem, and in one case with a Nike crossbody bag, which, by the way, everybody who wears those wears them like that across the chest. That's why they're called a crossbody bag and not a fanny pack. So the fact that he wore it in the manner in which it was designed to be worn is not a specific identifier linking him to these crimes. And so based on the absence of any specific identifiers given by the victims, the post-incident, which was almost immediately, it's not like they waited weeks and weeks and weeks to report the crimes. They talked to the police immediately following each incident. The fact that none of them was able to give any specific identifying features of the assailant, and then come into court and identify with 100% certainty that Mr. Glover, the only black man sitting in the courtroom in prison garb at the defense table, is absolutely the person who robbed me, is just not reliable. And that's really the focus that you should internalize, I guess, that it's not reliable, and that's the only thing that the judge could have possibly relied on in finding him guilty. That all of the victims identified him. I believe, this is what the judge said, I believe the witnesses, the victims, when they say they identified Mr. Glover as the perpetrator. And then with regard to the sentencing, she said, or the trial court said, you are not, basically you're not savable. You're beyond redemption as a basis for sentencing him to 60 years. The man's 22 years old. He has a high school degree. He has children. He has no prior felony convictions. He had some, I don't know, incident in school, but certainly not a track record of violent crime. And so for all of these reasons, I would ask that the court reverse the convictions, vacate them, and reverse the case for a new trial and at a minimum for new sentencing.
Thank you.
Thank you.
Thank you both for your arguments this morning. The case will be submitted, and we'll get out a timely written decision. Hope you have a great day.